Senator McPhedran.
Thank you very much, Your Honour. I'm from Treaty 1 territory and the homeland of the Red River Métis Nation. And I'm very proud to be part of a network of parliamentarians working closely with Indigenous leaders from my province. Earlier today, the chief, the Grand Chief of the Southern Chiefs in Manitoba issued a statement that made it very clear that Grand Chief Daniels was calling on us to amend this bill and to once and for all propose to the government what was needed to be done to actually fix and eliminate sex-based discrimination in the Indian Act. I'm also honored to be a member of the Senate Standing Committee today, as I was when APA dealt with Bill S-2. This government, through Minister Galmasti, insists on the Senate not amending anything until after the minister finishes what she has described as a mandatory consultation process. Please keep in mind that the wrongs addressed in this bill, so well described by Senator White, will be corrected in the amended bill presented to this chamber by APA. Yes, this is the first Indigenous woman in this role, and she does deserve great respect and appreciation for her office. But this is also a minister who admitted to APA that she has not started her consultation, and this is a minister who is in a minority government that narrowly stayed in power just days ago. The fact is, this is a minister who is making promises, albeit in good faith, that she has no capacity to keep because she could be switched out at any time. And this is a minority government that could fall any day. Sadly, it is also a fact that Bill S-2, entitled An Act to Amend the Indian Act, Elimination of sex-based inequities in registration, gained support over 7 years ago because of promises made by this minister's predecessors, promises not kept by each Liberal government since. In May 2017, former Minister Carolyn Bennett told the Senate APA committee, quote, "I think it's important to clarify what the government means by addressing, quote, known sex-based inequities in Bill S-2. First, I need to be very clear. Charter compliance is not negotiable. Bill S-2, as amended, will remedy known sex-based inequities relating to the registration in the Indian Act, which falls short of charter compliance." I'm continuing to quote Minister Bennett. "This is not restricted to situations where a court has already ruled, but extends also to situations where the court has yet to rule, and where we believe a sex-based charter breach would be found." End of quote. Colleagues, Bill S-2 was formerly known as C-38 prior to the most recent prorogation of Parliament. In the lead-up to C-38, according to Indigenous Services Canada report entitled The Annual Report on Registration under the Indian Act, First Nations Membership and Status Cards - 2023, there were 50 individual consultation sessions, 95 organizational sessions, 40 government sessions, 55 sessions with First Nations communities. Indigenous constitutional expert Dr. Pam Palmater compared the hard-to-find consultation in Bill C-5 to this Bill S-2. quote, "There were a lot of First Nation leaders that came forward in opposition to the Building Canada Act, stating that there needed to be more consultation. But it seems as though the government is selective in when they say we need to consult versus when they say that the Miscue Cree decision says consultation on legislation isn't required because it undermines the role of the executive and legislative branches." Earlier today, Government Representative Senator Laboucan Benson sent to all senators a statement by retired senators, the Honourable Lillian Dick and the Honourable Sandra Lovelace-Nicholas. In both houses of our Parliament and across this country, the greatest of respect and appreciation must go to these courageous and visionary Indigenous women leaders. And with such respect and appreciation, as one of the senators referenced in that joint statement, along with Senator Tanis and Senator Pate, I was on APA and deeply involved in the Bill S-3 process some 8 years ago. I wish to address only one point in the statement sent to us today, and I quote, that second-generation cutoff perpetuates sex discrimination against women who marry non-status partners. Not true, end of quote. I am on the record in the recent APA committee proceedings on Bill S-2 as having said that I believed what happened with Bill S-3 fixed sex-based discrimination in the Indian Act. Allow me to explain. I believed then, but not now, that the promises made by the government to move rapidly as part of the deal for S-3, I believed then that the S-3 package would be delivered. I was honored to be with Senators Dick and Lovelace-Nicholas in Saskatchewan in 2019 when then Minister Bennett announced the federal government had brought the final provisions of Bill S-3 into force, allowing registration by First Nations defendants born before April 17, 1985. Minister Bennett stated then, quote, "Gender equality is a fundamental human right, and for far too long, First Nations women and their descendants have continued to face the effects of historical gender discrimination in Indian Act registration going back to its inception 150 years ago." She continued by saying, "I stand in solidarity with the Indigenous women who have been working so hard for decades to end sex-based discrimination in the Indian Act registration and am proud that today all remaining gender discrimination has been eliminated from Indian Act registration provisions." End of quote. Between 2019, when that quote took place, and now, the APA committee issued its powerful and concise report, Make It Stop, because the governmental promise of the S-3 package was not kept. Colleagues, I see now that I was wrong, and here we are, with the current minister giving commitments as her predecessors also did. With regard to the assertion in the statement you received today that there is no sex-based discrimination with the second-generation cutoff, I offer for your careful consideration the following points in response. Senator Francis quoted the Equality Rights Section 15 of the Charter. There are two notwithstanding clauses in the Charter. Section 33, with which you will be most familiar given current uses of this clause by governments wishing to violate Charter rights. It is the other notwithstanding clause that is most relevant to reinforcing Section 15 of the Charter in addressing sex-based discrimination in the Indian Act. And it states, "Notwithstanding anything in this Charter, all the rights and freedoms referred to in it are guaranteed equally to male and female persons." With appreciation to Dr. Pam Palmater and the other experts in the working group that has been dedicated to research and advocacy to remove sex discrimination for 40+ years, here are some points for you to consider when looking at the statement from today. Second-generation cutoff is both sex and race-based discrimination. It is also arguably discrimination on the basis of ethnic origin and marital status. It is incorrect to argue that it is not sex discrimination and only race discrimination, as any discrimination violates sections 15 and 28 of the Charter. First Nations women suffer intersectional forms of discrimination because of their sex as women and their race as First Nations. The National Inquiry into Murdered and Missing Indigenous Women and Girls explained that while all Indigenous peoples suffer from historic and ongoing genocide, Indigenous women suffer from unique, gender-formed genocide. Sex discrimination is evident in the second-generation cutoff. For example, there are unequal family units created. Before 1985, when First Nations men married white women, the white women gained status, as did their children. First Nations women marrying a white man lost her status, as did her children, and her grandchildren, and her great-grandchildren. Even when the law was changed to reinstate these women, it did not treat them equally as their white husbands, did not gain status. Now, this is not about wanting to give white men Indian status, but it is about unequal, disproportionate impact on an Indigenous woman's family as compared to an Indigenous man's family. In the man's family, they are considered a family with two status Indian parents, with two sets of benefits, two sets of per capita payouts, two sets of treaty payments, meaning he, his wife, and children get more than, for example, his Indigenous sister. In the woman's family, there is only one status Indian parent, and thus only one set of benefits, meaning she, her partner, and children receive less. I would like to now turn to the APA report tabled in this chamber and the non-liability clause in Bill S-2. Is it not shameful for this government to insist on perpetuating non-liability clauses that forbid Indigenous women to seek compensation for the harms done to them under the Indian Act? The way in which this was addressed in Make It Stop, which was adopted by the Senate, was Recommendation 7, which reads that the Government of Canada introduce legislation to enable First Nations women and their descendants to access compensation. The minister at the time rejected this recommendation with this vague point, quote, "The validity of these clauses is being assessed and determined by the courts." Let me ask you, what is the responsibility of government to address sex-based discrimination that has been found by courts and international courts to be illegal? The fact that a provision is being considered by a court does not prevent Parliament from changing or repealing that provision. This government, like its predecessors, bit by bit over decades, does the minimum, only when forced to do so by a court, and that is what Justice Mass criticized so clearly in the Deschanel decision that led us to S-3. Denying access to compensation to women with their children and grandchildren and great-grandchildren who have fought for decades against sex discrimination perpetuates that discrimination. And, Senators, that discrimination is illegal. Please note that bars to compensation apply to all causes of action, even those that are not under the Charter. In charter cases, Crown immunity for damages arises from enacting legislation set out in the case Canada, Attorney General versus Power. The case brief from the Supreme Court of Canada notes, and I quote, "Writing for the majority, Chief Justice Wagner and Justice Karakatsanis held that the state is not entitled to an absolute immunity from liability for damages when it enacts unconstitutional legislation that infringes."
Senator McPhedran, I'm sorry to interrupt. Your time is expired. Are you asking for more time?
I would greatly appreciate that.
Is leave granted, honourable senators?
Thank you, colleagues. By shielding the government, and I'm continuing to quote from the Supreme Court of Canada, by shielding the government from liability in even the most egregious circumstances, absolute immunity would subvert the principles that demand government accountability. Power reaffirms the law as it has stood for more than 20 years under Mackin versus New Brunswick and Rice versus New Brunswick. The Senate APA Committee's amendment removes the bar to liability with respect to the harm caused to the wives and children of men who enfranchise by having their status automatically removed, and those who lost status or whose descendants lost status because of the second generation cutoff or the 1985 cutoff. Following the Power decision, the standard will be whether these bars were legislated when the state, quote, knew that the law was clearly unconstitutional or was reckless or willfully blind as to its constitutionality, or the enactment was an abuse of power. This government, through Senator Moreau, is asking senators to protect the ban on damages in Bill S-2. So I must ask, what will be the effect on the government of not passing that section? A number of international human rights bodies, including the UN Human Rights Committee in McIver and the UN Committee on the Elimination of All Forms of Discrimination Against Women in Matson, have called on Canada to provide compensation for decades of sex discrimination in the Indian Act. How can the government justify leaving the non-liability clause in place in light of the decisions of UN committees calling on Canada to provide an effective remedy and reparations for discrimination and forced assimilation practices? How can this government's denial of access by Indigenous women and their families to compensation, resulting in forced assimilation practices with impunity, how can this be justified? Removing the non-liability clause will not cause a floodgate of lawsuits, given the difficulty, the expense of bringing them, nor is it a valid aim to restrict access to justice. The effort to restrict compensation harkens back to former Section 141 of the Indian Act, which prohibited Indigenous people from hiring lawyers or collecting funds to advance claims in court from 1927 to 1951. A throwback, in other words. A disproportionate number of those affected by the lacunae in S-2 causes them to be deprived of Indian status, and a disproportionate number are single mothers with children. These women and children will continue to be denied the tangible benefits accruing to status, like medical care, income, educational support, and the right to live on reserve. They also lose the right to pass on status to their children, which the cases of Lovelace, McIver, and subsequent cases describe as a personal right, while acknowledging broader cultural dimensions. The losses to individuals, families, and nations caused by deprivation of status are significant, and in some cases extend over many years and generations. The damage cannot be repaired simply by having access to the benefits once individuals are registered. The law must be changed. The discrimination in the law is illegal and unconstitutional. I hope this information is useful to your careful consideration of this historic deliberation. Miigwech, merci, thank you.